Okay. All right. So we're now recording this event as well. All right. So again, my name is Kalea Edmundo. I'm a staff attorney at Central Jersey Legal Services. And what we're here to talk to you today is about planning for the unexpected. For myself, I've been an attorney since 2009. I have a bachelor's degree in criminal justice from Fairleigh Dickinson University. I also have a master's in public administration. I received my Juris Doctorate from David A. Clark School of Law in DC. And a fun little fact about myself is I'm named after Princess Leia from Star Wars. So I just wanted to start with that. Now, when we're planning for the unexpected, we can't just believe that planning is for death. Planning is also for incapacity. I have a nice little quote from Benjamin Franklin that says, "But in this world, nothing can be said to be certain except death and taxes." So even though estate planning involves talking about death, it's more than just talking about death. It's about making a plan for yourself and your loved ones. So the first thing that I like to do with everybody is I like to have a little pop quiz. So let me read the question to you. What do these famous people have in common? We have Abraham Lincoln, Prince, Aretha Franklin, Amy Winehouse, Bob Marley, Jimi Hendrix, Sonny Bono, Kurt Cobain, Dr. Martin Luther King Jr., Marvin Gaye, Billie Holiday, DJ AM, Chadwick Boseman, and John Singleton. So I'm going to operate the poll, and I'll give you guys a few choices. So with this, you have three options. The first one is they are all rich. The second option is they are all dead. And the third option is they all died without a will, a last will and testament. So if you can make your selection, I'll give you guys, about 30 seconds, 40 seconds or so. And I'm going to see what the numbers look like. So far, some people already know. Okay. I'll give you guys a little bit more time because we have 13 attendees. 7 people have answered. Okay. 61%. Let's see. Looks like some people know the answer, even though I think all the answers are winners. But some people know the answer. So we have 9 out of 13. All right, we're into 45 seconds. I'll give the people who just came in a chance to answer with this with this poll. I'm going to end the poll in about 3, 2, 1 seconds. Okay, we have one more. Okay, so let's share the poll results. Everybody said they're all rich. Some people were richer than others. Some died, unfortunately, poorer than others. They are all dead, which is true. They all are dead. But what's most important to know is they all died without a last will and testament. Okay? So I'm going to stop sharing those results, and I'm going to close out of that. Now, what's difficult is when you die without a will, this is what's called an intestate estate. What's surprising is most people die without a will. And what does that mean if you die without a will? That means the state decides by intestate distribution, not you. So your beneficiaries are chosen by state statute. So in this intestate distribution, the first person who would inherit is your spouse, your children, your next of kin, like your parents or your siblings. So unfortunately, if you had a friend or if you wanted to leave money to a charity, they are left out. And let's say if you don't like your kids, they are in. Now, the other thing that happens is someone must apply to become the administrator of your estate. So they have to secure a bond for the estate to protect it from fraud. And fraud is a big thing. because now the person administering your estate is someone you may not have wanted to choose in the first place. Now, the other thing is for those of us that have children, and especially for those who have adult children, they never want to spend their own money on their parents. So if you want your kids to save their money and you don't want them to have to pay the bond and the fees to be the administrator, do your estate plan. That's always my dad's favorite joke. Now, why prepare your estate plan, you ask? This puts you in charge of your assets, how they're handled, how they're distributed, and your healthcare decisions. It also gives you assurances that your wishes are followed. And my favorite part, it takes the decision making away from your family and your friends or anyone else who you don't want to handle it. The power is now in your hands. I think what's important is when you're doing an estate plan, you are making a decision on how to distribute your wealth, distribute your assets. Okay. Now, we're going to have our second pop quiz. Any good estate plan has a will, a last will and testament, a power of attorney, and an advance directive or living will. And we're going to talk about each component. But for this poll, I am interested in knowing how many people have done an estate plan. Yes, if you have, no, if you have not. And I'll give you guys about 40, 50 seconds to answer that question. Okay, a little more time because we do have 14 attendees. Okay, very good. Okay, let's see. Almost everyone has voted. Well, we have 9 out of 14. I'll give you about 15 more seconds for the vote. And if anyone doesn't know how to use the voting features, it's right on this front of your screen. You should be able to see it. All right, I'm going to end the poll in about 5 more seconds. We'd appreciate it if everyone can vote. Okay, 5, 4, 3, 2, 1. I'm going to end the poll and share the results so this way we could see. So I see most people have an estate plan, so that's very important. And some people don't, and I'm glad that you're here because we could talk about that too. Okay, so I'm going to stop sharing the results because having an estate plan and updating an estate plan is also very important. If you have an estate plan, you want to ask yourself a couple of questions. You want to, anytime it's a new, let's say, change in family, like let's say if you've divorced or if you've lost a spouse, if there's a serious illness, if you, for example, if it's a new decade or you haven't done your will for 20 years, there might be some changes. So you want to keep all of these things in mind because wills from time to time do need updating. So if your will is 30 years old, I would really consider it, 10, 20, 30 years old. Okay. Now, in any good will, or actually in every will, you want to have what is called an executor or executrix for your estate. I put everything in mail form. Please forgive me. So just know when I say executor, it could also be executrix. Now, naming an executor, this is the person who you are appointing to administer your estate. All right. With the executor, this is a position of trust. These are one of 2 people who are key appointments in your will. All right. So there's the executor, and then there's the funeral agent. And I'll talk about the funeral agent shortly. Now, the executor, what they are doing is they're responsible for marshaling your assets and paying your debts. They're not using their money to pay your debts. They're using any monies that are in the estate. One of their jobs is to locate the will, so they should know where it is, and to obtain the death certificate and any important papers. After you die, there is a 10-day waiting period before the executor could probate or file for probate in your estate. Okay. And during that time period, what the executor should be doing is making a list or an accounting of all your property, your stocks, your bonds, your bank accounts. Their job also is to locate all heirs and next of kin within a 60-day period and let them know that there is a will. And the executor is also responsible for paying your final expenses, including your funeral, expenses related to your last illness, administration costs, and even the filing fees to probate the will. And again, they're not using their money to pay these things, they're using the money from the estate. They also have to look at all claims against the estate, whether there's any debts or taxes you may owe. And then and only then do they distribute the remaining property in accordance with your wishes that are expressed in the will. What's good about naming an executor is you also can waive the bond requirement, which bonds are very expensive. Just on average, a bond costs, for every $100,000, a bond usually will cost $1,000. So if you have an estate that's worth $300,000, that's a $3,000 bond. And the bond must be renewed every year that the estate is open. So it could be very expensive. So if you want to save your loved ones some money, have a will. Okay, that's my best advice I could give anyone. Another job, and this isn't a whole list of what an executor does, but they also file your last tax return, which is due within 8 months of your death. Now, when you appoint an executor, don't just pick someone because of your kid or you love them or you care about them, because someone could be a great kid or friend, but they could be awful at managing money and they could be awful at meeting deadlines. You want someone who you believe will get the job done. That's the most important thing. Now, with a funeral agent, this is the person who they should have a relationship to you. It shouldn't be a stranger. This is a mandatory provision that can go in your will, especially if you're being cremated. And with the funeral agent, you would direct to them by letter on how you want to dispose of your remains. So cremation, burial, memorial service, funeral. Something you want to think about is, why do you want this person to be your funeral agent? Is it because they're going to get the job done? Or is it because you have sentimental feelings towards them? I would say pick the person who's going to get the job done with the least amount of drama. Now, the funeral agent is not responsible for paying for your funeral. If you're concerned about having the funds to pay for a funeral, then consider doing a prepaid funeral trust or working with a funeral home to prepare your final plan. I think that's the most important thing. I have other clients that maybe have a life insurance policy for the purposes of planning your funeral. But if you're going to go that route, whoever's getting the policy needs to understand that they are supposed to use those funds to pay for the funeral. And that's why I tell people maybe a prepaid funeral trust would be the way to go. Okay, now let's go to the next slide. Oh, good. Oh, and I guess I should, oh no, we'll come back to that. There are two types of assets that can go into, that we're talking about, that you own, not that goes into the will, but what you own. You have probate assets and you have non-probate assets. Probate assets flow through your will. So those are those assets that you own solely, that it's just owned by you: real estate, bank accounts, securities, and assets that trigger an estate. So for example, a wrongful death lawsuit, other tangible property. Now, non-probate assets, however, they do not flow through a will. These have a specific beneficiary designation. So life insurance policies, funeral insurance policies, retirement, pension, bank accounts that are payable upon death, so a POD account, or any jointly owned property, that has a right of survivorship. Like, for example, if you own the property husband and wife, then that house would go directly to your spouse. It wouldn't go through your will. And then we have assets that are owned by way of trust. So let's say if you have a trust fund that's supporting you, the way that asset is distributed after your death is decided by somebody else's will, not yours. Okay, so that's just very important. Now, when we're looking at property and I'm working with clients, what I like to figure out first is, how do they own the property? Is it owned individually or is it owned jointly? So for example, like I mentioned earlier with a home, the deed will always trump the will. You can't take joint property and leave someone else's share to someone else, okay? So like, for example, if you're not husband and wife and you're family members and you you purchase a home and you own it as joint tenants, if it doesn't have that with rights of survivorship, then what happens is each party owns the home 50-50 or however it's designated in their deed. So with one of the people dying, their interest in the home doesn't pass to the other owner, it passes through their estate. And they also have to look at, there's assets that are not always created equally, such as annuities. People assume that your spouse will get the rest of your annuity. You need to make sure that's so, or they assume that their children will get the annuity, or so on and so forth. And that's not always true. So you just want to be careful with that is all. Now, next, after we've determined what kind of assets you have, then we need to determine, who are you leaving everything to? Who is your next of kin? Okay. The term of art is, in order to make a will, you need to know the natural objects of one's bounty. So that really just means your closest surviving family members or whoever it is you want to inherit. So your next of kin first is your spouse, and we'll talk about a little later if you're separated from your spouse. Your children, this includes all children from prior marriages and relationships. This includes any non-joint children with a current or former spouse. Let's say if you adopted a child, or if there's children under the age of 18, there are certain provisions that you want to take into place if you are leaving part of your estate to a minor. If you have any parents, siblings, friends, charities. Then what's also important is, if we're making a will, if you are disinheriting anyone. So for example, if you're leaving assets to a specific group, right, your children, but there's one child who you're going to disinherit, it's very important to put that disinherited language in the will, because if you fail to put it in, this could create problems. And the reason we specifically disinherit is so that way there is no question that this person was accidentally forgotten or admitted. All right. Because if it appears that someone was accidentally forgotten or admitted, that person could later challenge the will and ask that they be allowed to inherit under the laws of intestacy. And that's as if the will never existed. Now, if you're working with an attorney on your will and you want to disinherit someone, it's important you let your lawyer know why, because we keep notes on those things. What I also ask clients to do too is, if you're disinheriting someone who's of a close relation, I like you to include a letter. I can include it when I have clients, I make a photocopy of it, I put it in my file, and then I have the client put the letter in a sealed envelope and they sign the back of it, and they make it out to the person who they're disinheriting. So this way there's no question, at least they're explaining it, why they're not inheriting. And like I tell clients, you are going to be gone, so it's not that they're going to see it. I think it's important because sometimes, especially with clients, if they have a child, let's say with a substance abuse issue, if there's a child they helped out a lot, they could explain that. And usually when the kids see it, they would hopefully understand. All right. Now, there with any, oh, let me see, I just want to make sure I'm not missing something before I move on to the next slide. Okay. And with any will, you want to make sure that it works as you intend it to work. So for example, if you have a pet and you want your pet to inherit your entire estate, you need to figure out a plan on how that would work because pets are property. Okay. So, or let's say if you have a minor child who is inheriting your entire estate, you want to make sure you have the mechanism in place for them to inherit. Because children, if there is no, let's say if you were to die without a will, or if your will doesn't make any provisions for a child under 18 to inherit, then that child, you could risk them not even being able to receive a dime until they're 18. But we'll talk a little bit more about that later. Okay. Now, surviving spouses have a right to pursue what is called an elective share. And with that elective share, so let's say if you're divorced, automatically cancel the ex-spouse. Or let's say if there was, you're divorced and there was a settlement agreement, you may have marital interest in a property that was decided by a prior divorce. So that's different. But if you have a current spouse, that spouse is entitled to 1/3 of the augmented estate. So that means the estate would be reduced by funeral and administration expenses and enforceable claims. Then that spouse would be entitled to 1/3. If you are separated from your spouse, including divorce from bed and board or annulment, at the time of death, then the spouse is not entitled to the share. In order for them to pursue this elective share, parties must continue to cohabit as a married couple. And it would be up to the surviving spouse to pursue this augmented share, not the other way around. But if you have questions about this, it's important that you speak to an attorney who can give you more information in your specific case. Okay. Now, I want to go to the next slide. Disposing of your assets in your will. So you need to look at first, are there any specific bequests that you want to do? So for example, a specific bequest is, I want my car to go to my oldest child. I want my house to go to my youngest child. I want my pets to go to my next door neighbor and best friend. Things of that nature. You could also have a personal property memorandum in your will. And I like personal property memorandums because this is for property that could have value, but also has sentimental value. Like, for example, I want all of my artwork to go to my best friend, or I want my dining room set to go to my son, or my wedding ring and engagement ring to go to my daughter. The personal property memorandum, or also known as a letter of instruction, it needs to be signed by you. You can update it periodically if you want, and it would go with the will. It wouldn't change any of the other provisions of the will. It would just be updated as you need it. Now, and if you do update it, make sure you get rid of the prior version. So that's what's important. Now, if you have children under the age of 18 who you want to inherit property, what you have to do next is you need to create in your will a testamentary trust. So this means that the trustee, who is the fiduciary of this money, is holding this money in trust for the benefit of someone else. They can't use it on themselves to go to Hawaii or anything like that. The trustee can only distribute the funds to the beneficiary in accordance with the terms in the trust agreement. So I'll give you a perfect example. You could say that your grandkids get the money you're leaving them upon their 18th birthday, 21st birthday, 25th birthday. I always like to tell a story of one of my friends who her grandparents passed away when we were in high school and there was money in trust for her. It was like $30,000. And the funds in the trust were distributed to her on her 18th birthday. Well, I will tell you that money was gone within 6 months. So you have to think about the minor who you're leaving the money to. Are they going to be mature with the money, or do you think that they will be a little immature with it? If you think they're going to be a little immature, you may want to consider an older age. Now, with testamentary trust, it must be created in the will. Okay. And with anything in here, beneficiaries, you always want to plan on an alternate. Same for any trust, executor, or funeral agent. You want to have alternates, because when you create your will, people do pass away, or things happen, or become, incapacitated. So you want to make sure you have that secondary alternate. And sometimes, if you really think you need it, a third alternate, but it's not a requirement. It's just a suggestion. Okay. Now, we already talked about leaving inheritance to minor children. Something else that we could talk about as well is the special needs trust. This is if you need to leave money to a disabled adult child. Why this trust is important is you want to have this special needs trust for a child who is unable to work, on disability, because if they were to inherit outright, then what would happen is this could reduce or terminate the type of aid they are receiving from government benefits, such as Social Security or Medicaid. All right, so that's also very important. Now, when you're making a will, there are some legal requirements for the testator. And with those legal requirements, one of the things that I look for is, first, you have to be over the age of 18, which I'm assuming everybody is. All right. So you have to understand that you are making this will, you're of sound mind. Nobody's forcing you or coercing you to do this. You don't need to know all the legal terminology, but what you do need to understand are the consequences of executing a will. Now, having the capacity at the time of the initial meeting and also at the time of the signing of your will. You need to be able to identify who are your beneficiaries, who are your relatives, and what property are you leaving them? And if how you dispose of your property in your will, how it all works. Something that I look when I meet with clients is I make sure that they have the capacity to proceed. We do a few little testing things in the office, but we are not medical professionals. We're just trying to assess for legal capacity. Medical capacity is something different. Every will has to have 2 witnesses who sign, who are also over the age of 18, who are of sound mind. And if you need, let's say right now with the pandemic, Governor Murphy signed into a temporary law of remote notarization. Witnesses could be anyone. They could even be those who are inheriting under the will. Now, next, if you want the document to be self-proving, which is what attorneys recommend for any will that they're preparing, the testator would sign the acknowledgement. That's the person making the will. 2 witnesses would sign an acknowledgement stating that they appeared in front of the testator and witnessed them signing. And then an attorney or a notary would acknowledge all the signatures of the individuals. And there are different types of wills, but I'm not going to get into it. This is the most standard, and I feel like this is the one that offers the most protection. They do have holographic wills, which is a handwritten will signed by the testator, or writings intended as a will. You have to show the clear and convincing evidence would need to be shown, but those would require litigation, and that's something my office does not handle. Okay, so first what I want to do is temporarily stop the share before I go on to power of attorney, just to find out if anyone put questions in the chat. Okay, so if there's no questions in the chat, I am going to go back to sharing my PowerPoint. Let's see, I have to do this again. All right, share screen. Okay, before we start talking about the power of attorney. And I know this is a lot of information. We are recording this, so I don't know how we'll make it available. It'll probably be on our website. Now, a general durable power of attorney. What is it? Just like the document, the will is the document that's planning for your death. The power of attorney is the document that's planning for your incapacity. Now, most attorneys, including our office, prepare this general durable power of attorney, and it's a contract. And to do this, you must have the capacity to contract, which is a higher capacity, believe it or not, to make a will. Now, why it's important is in this document, you as the principal are giving the agent the ability to make financial decisions on your behalf, because in absence of a power of attorney, no person, including your spouse or children, can make these decisions on your behalf on non-joint accounts, non-joint assets, etc. Loved ones will find themselves unable to access solely owned assets, and instead they must obtain a guardianship of you, which is a long and costly process, because to do the guardianship, some people do it on their own, but the court would appoint an attorney to the incapacitated person, and the petitioner would need to get 2 doctors to certify that the individual is incapacitated. And that could be very costly, between getting the 2 doctors to do the certification, because that has to be done in a certain way. There could be testimony taken, and you as a petitioner would have to pay for the court-appointed attorney for the person you're seeking guardianship of. I really think that it's important to do this power of attorney and this will while you have the capacity to do it. Don't wait until, you're so far gone that no attorney is going to be able to do this for you. So that's just another important thing that I wanted everybody to know. Now, in this power of attorney, you are the principal. You're the one who signs the power of attorney and grants the powers to the agent. The power of attorney gives the agent, also known as the attorney in fact, the power to act on your behalf in financial matters. The agent can't represent you in court, but they can communicate with your attorney on legal matters. The agent has a fiduciary duty to you. So this is a duty of care. Just like how I listed similar with the trustee, the agent must use your funds in the way they were authorized to do it. Now, you always want to pick a trustworthy person, because the agent acts with very little, I'd have to say, oversight, unless you put those provisions in your power of attorney. So you want to pick somebody who's trustworthy. You can have co-agents, but I tend to dissuade individuals from doing that, because with co-agents, either they're allowed to act together or act separately. If they have to agree on everything, you're asking for your loved ones to be going to court every time a major decision has to be made. If they act separately, you're asking for people to go to court because they're not going to be able to agree and move forward. I think what would be good is you assign one person as the agent, and then maybe the second person as an alternate agent with rights of yearly review. Like, for example, if you wanted to have limits on financial transactions, like any check over $500 that's written has to be signed off by the co-agent, or the agent has to show the co-agent yearly statements every year, something of that nature, if that's your concern. And especially if you're working with, your kids, you may want to consider doing that, because then it'll keep the fighting down, hopefully. Now, when issues arise, something that's important is you as the principal, as long as you have capacity, and no one could say you don't have capacity, okay? The only person who could say you're incapacitated is a court. As long as you have capacity, You have the right to agree, disagree with your agent when you see fit. Just because you have an agent, it doesn't mean that they own you or rule you or decide every little thing that you have to do. You could still say no. No, I don't want you to sell my house. No, I don't want you to take my money out of this particular bank account. I wanted to stay here for a reason. No, you can't use my money to buy XYZ. You have that right. So don't feel as though because you have, because I know some people are hesitant about the power of attorney because they think that it means that you lose all rights and somebody's going to be charging in and bossing you around. That is the furthest from the truth. Okay. And this is why you want to pick an agent as someone who's trustworthy, of good character, understands how you manage your money, understands how you do certain things, and is willing to compromise. Now, one thing that I tell people is being appointed the agent is a thankless job and it should not be considered an honor because the person you appoint will be using their time and sometimes their resources with little or no compensation to act as your agent. So this should not be a surprise. This should be an ongoing conversation. Just like the executor. I don't think the executor or the funeral agent or the trustee should be a surprise either. These are conversations that you want to have with the individuals before they are appointed. Because what if they say no? Now it goes to the alternate, who any alternate you assign, you should also be having a conversation with that person. Okay? Like I say, don't spring it on someone because it might not have the result that you want. Now, the power of attorney is only good while you're living. It ends at your death or if you revoke it. If you're revoking a power of attorney, it's very important that you see an attorney for the revocation because certain things need to be sent out to the agent who you're essentially firing. And if you own property, the revocation should be filed with the county clerk's office where the property is owned. Okay. Now, with the durable power of attorney, there are two types. This includes you can have the power of attorney effective immediately, it's effective upon signing, and it survives disability, which is great. And just because you have it effective immediately, it does not mean you have to give it to the agent right now. You can hold it somewhere that's safe. With any power of attorney, please don't leave it in your safe deposit box. Or if you leave it in your safe deposit box, please make sure the agent has a key. I'd prefer you don't have it in the box because if the agent needs it and the bank doesn't let them in because they're not you, the bank is not going to let them in because they say they're your agent. They need the actual document to prove that. Now, there is a second type of power of attorney, which is called springing. It only goes into effect upon disability. It has to spring into effect. And the agent would need to get two doctors to certify that you are not able to act on your own behalf. The advantage to a springing power of attorney is it is to ensure that it's protecting you from improper use. The disadvantage is the time that it would take the doctors to prepare the certification, and some banks may not honor a springing power of attorney unless you actually provide the bank or your agent provides the bank with proof that you, the principal, is actually disabled. This springing power of attorney leaves too much discretion to the banks. And I think that it would be, talk about the pros and cons of both, but I tend to see more clients who do immediate power of attorneys than springing. Okay, but that's just my personal opinion. Now, what makes a good agent for a power of attorney? And I was talking about that a little earlier. Someone of good character, who has good financial skills. You really don't want to pick somebody who's done a bankruptcy or got credit problems or things of that nature, because as good intentioned as people are, if they're in a hard or tough financial place, they may borrow your money with the intention of putting it back, and then it doesn't happen. Okay? You want somebody who has good organizational skills, who has a relationship to you, a personal relationship. You need to determine if there's any personal challenges. Like, for example, are they across the country? Not that they can't be your agent if they're across the country, but it's a consideration that you have to think about. Are they willing to serve? Are they available to do the job? Are they able to take the time on and responsibility of being an agent? Because like I said earlier, it's a thankless job, okay? If you have a power of attorney, and let's say if your ex-spouse is named, you want to make sure you update that, okay? And it's important that when you pick the agent, you talk to the agent about your expectations, how you pay your bills, how you manage your money. Do you want them to be able to make gifts on your behalf? Power of attorneys in New Jersey could just be notarized. If you're going to, or witnessed by an attorney, if you're going to be moving out of state, it's important that you check with that state to see if your power of attorney would be valid there. I know some states require the notarization in 2 witnesses or 1 witness, or there's another state that requires 3. So it's just good that you know that, especially if you're making plans to move. Now, you don't want to make copies of your power of attorney. 1 copy, fine, keep it somewhere safe. You should always have the original. I don't agree with people making multiple copies and then handing them out to all their kids, because then that's going to be a problem. But everybody should know, not everybody, your agent and your alternate agent should know where you're keeping this. Now, something that's been happening with banks is if someone is a non-relative who was appointed as the agent under your power of attorney, it's a 10-year limit. Check with your bank so you're not surprised later on. And some banks actually will have you fill out their own little card. Make sure you do that. All right. So that's also important too. And you could take the power of attorney to the bank. It doesn't have to be anyone else. Okay. Now, we're almost done wrapping up. An advance directive for healthcare, also known as a living will. This is the document for when you're not able to make decisions for yourself, medical decisions for yourself. You would appoint someone to become your proxy. So in the event of your incapacitation, what would happen is a doctor, your treating doctor, and 1 other medical professional would need to put documentation in your file before the proxy can make decisions regarding your medical care. So when you're doing these forms, there's a couple of ones we put up. State of New Jersey has a common form. There's 5 wishes forms online. Private attorneys, we can also prepare them as well. But important questions you want to ask yourself: do you have a living will? Do you want to donate your organs? Are there any significant health issues? When you appoint a healthcare proxy, they receive the same information as you do. They have the right to confer with the medical team, review your medical chart, ask questions and get explanations, discuss treatment options with medical professionals, request consultations and second opinions. They can consent or refuse medical tests or treatment for you, including life-sustaining treatment. They can authorize the transfer, your transfer to another medical hospital or doctor or care center. I think with this, planning is key because you want to avoid conflicts with family members. And this is why you need to have a talk with them. You don't have to tell everyone, but for example, if your intent is not to have life-sustaining treatment, it's important that your proxy and your alternate proxy know of this. So since my time is limited, I'm not going to go over every single form, but what I wanted to tell you is with updating your plan, your estate plan, anytime there's a new trigger, if you reach a new decade in your age, if you experience a death of a loved one, if you experience a divorce, a diagnosis of a significant health condition, you experience a decline in your functional condition, or even if you change where you live, if you move to another state, you want to update your plan. Now, fun little tidbit, I always like to add this in. Be mindful of scams that are targeting seniors. Sometimes they come by phone, pretending to be the IRS or collecting a debt or ordering prescriptions or medical equipment you don't need. We've seen some where someone will pretend to be a long lost relative or a long lost love or a grandchild that they need bail money. Call your family member before you give anybody money, because you'll get a message on Facebook, Grandma, I'm in jail, don't tell mom. Call your child and find out. Don't just assume that this is your grandkid really in jail. It could be, but wouldn't it be nice to know before you give the money? And if you are, you could report scammers to the Federal Trade Commission. I have their website information up here. If you were scammed, it's important that you file a police report and you contact the local police department. New Jersey has a, Department of Consumer Affairs to handle these types of cases. And here is our contact information. So this is all going to be recorded. And what I'm going to do, oh, there is a good question. So let me stop the share of my PowerPoint. Can you pass assets to grandkids bypassing your son or daughter? Okay, so with this, yes, you can pass assets to your grandkids and you could bypass your children. But before you do that, you want to ask yourself, why am I doing this? Do I want to leave my children maybe something or less than? So for example, let's say you have $50,000. You don't want your kids to get the $50,000. You want to go to your grandkids. If you don't want to disinherit your children all together, maybe leave your children a little something and leave a lion's share to your grandchildren. But just like with your grandchildren, if they are minors, there needs to be a mechanism for them to inherit. So when I was talking about earlier, that testamentary trust, that would need to be set up in your will. So this way your grandchildren could inherit those funds, because otherwise, yeah, you put it in the will, they're going to inherit, they're not going to be able to get the check. And for any type of will, the executor needs to ensure that all the funds are in there before anybody inherits. So you want to make sure that you have enough assets to cover your debts. So this way your children and grandchildren can inherit. Okay, so I'm just looking at the chat. I guess at this time, so with questions, they should be, not should, need to be, because there's no confidentiality here. They need to be general questions. So specific questions, you know, we're getting into the weeds, like a specific question would be like, oh, I'm divorced and my divorce decree said this. And it's like, no, we're not going to answer those types of questions here. But any type of general question, like the one was good about, you know, testamentary trust. So I appreciate that. If you want to put it in the chat, or if you want to unmute yourself and put yourself on video, I'm happy to take a question. I can hang around for a little bit of time. For my office, so what we do at, I'm one of the staff attorneys in the senior project. And what I do a lot of my work with is seniors to prepare wills, power of attorneys, and advance directives. 40% of my time is for family law. So I handle family law issues, including, you know, parenting time, custody, divorce, child support, things of that fun nature. I also work with Medicaid termination cases, and I also, maybe I'm being rotated out or maybe rotated back in. When I first was hired at Central Jersey Legal Services 3 years ago, I was doing tenancy. Prior to my time at CJLS, I was practicing family law solely in Essex County for another nonprofit. Now, here's a question. If you have multiple children, so we'll go back to the executor, appointing an executor or executrix. You want to pick the person who's going to get the job done. I understand when you have a personal relationship to your children and you love your children, appointing them executor is not necessarily showing them that you love them. You don't have to worry about them being feeling left out, because you want to pick the best person as the role. So yes, can people have co-executors? I don't know if I would do that. I mean, you're going to pick what you want at the end of the day. I would maybe pick one child as the executor and the other one as the alternate. Because when you start doing all of these things, you're setting this up to what's going to happen if they don't agree. And kids don't agree. I have 2 siblings. I know we don't agree on stuff. So I caution you to think about maybe one alternate for the other. Because sometimes I have clients that have, I had a client that I met with before that felt every child had to have a job. And then from talking to the client, we realized that this wasn't the position for the kids because none of them were good with money. And then the client ended up appointing another relative to be the executor. So you know who your children are, you know who your family is. Now, if a person has very little assets, is it necessary to probate the will? That's a question of it depends. I always think everyone should have a will because let's say an asset occurs after your death, like an estate that triggers an asset, like a wrongful death suit. Now what happens? I also think if a will is important, even when you have very little assets, to determine what is going to happen to your remains. You may have one child that says mom wants to be buried and another one that says, well, we don't have the money for a burial, we're going to do a cremation, and now they're at our arms with each other. So take that decision making away from people. As far as whether if the will needs to be probated or not, that's going to be the decision of the executor. So you don't have to worry about if it's going to be probated. You need to worry about, should I be making one? And I think everyone should have one. I think it's very, very important. I think what's hard with wills is a will is accepting that one day we will not be on this earth. And it's hard for everyone to accept. But I think what's important is you want to have that plan established. So this way, when you have that plan established, you, when you leave this earth, can rest assured that everything you laid down will hopefully be followed, and that your family will be okay, and that the assets and the wealth that you did generate, no matter what amount it was, is going to go to the people who you have chosen. Okay. Now I see another comment. I am not admitted in New York, so I'm really sorry. I'm not going to answer this question here. As far as if there's no will and no close relatives, well, I mean, if this was New Jersey, somebody would still have to apply to be the administrator of the estate. So I think that's another question. I think that's another question. And then I see another message. If you can pick a child who lives in a different state, it doesn't matter if they live in New Jersey or not. New Jersey doesn't approve agents. When I mentioned the power of attorney, that's if you move to another state, you want to make sure that the power of attorney that you had prepared in New Jersey is still good in another jurisdiction. So for example, New Jersey only requires your power of attorney to be notarized. But if you were to move to Pennsylvania, they require the power of attorney to be notarized and witnessed by 2 people. So you want to just look where you're moving to if you plan on moving. If you don't plan on moving, that doesn't matter. Okay. Now, as far as I see some questions about assets and trust and things of that nature, my office, we don't do trust planning. We actually do very little because for our services, we are limited to representation of seniors who are low assets. So if you have assets, I mean, we're always happy to do a consultation for anyone who's eligible. But if you have significant assets that you want to discuss what should go on a trust, then I would highly suggest that you contact the Mercer County Bar Association, and they operate a lawyer referral service. And with this lawyer referral service, they can refer you to an attorney in your area. It's $25 for a, I believe, 30-minute consultation. And what I'll do is I will put their contact information in the chat for anyone who is interested. Okay. Now, other questions, as far as what would happen in the state of New York with old assets, I will tell you, I have no idea. I'm not admitted in New York. I wouldn't know. So I don't want to give anybody thank you, Susan. I don't want to give anybody misinformation. What I would say is if you have questions regarding property or assets in New York of a deceased loved one, that you should reach out to an attorney who's admitted in New York. It depends on there is legal aid society in New York, but it depends on what county the estate would need to be probated. And I will tell you, a lot of legal services offices, we do not do probate. So, I mean, that's the other thing as well. But if there are no other questions, let me just take a look, because now we are reaching the 12 o'clock hour. I hope the person who had the power of attorney question, if you could just put in the chat if I answered it. So the person you appoint as the agent of your power of attorney, it doesn't matter what state they live in. As far as the power of attorney, if you have it prepared in New Jersey, like I was saying, and you're in Jersey, and then you move to another state. Oh, good, thank you. You move to another state, you just want to make sure that state will accept it. Now, are there any other questions that don't deal with New York, but that deal with the presentation today? Anything that needs clarification? Because I think I'm going to be getting the little hook soon, but I want to make myself available. All right. And again, oh, good. I see a little hand. So let me ask you to unmute, because I see a hand raised. Oh, whoever's got the hand up, if you can unmute yourself and you could ask your question.
Just thank you so much.
Oh, thank you. Oh, this was wonderful. I'm so glad that you guys were able to attend. I really appreciate it. And again, I thank the West Windsor Senior Center for having us. We would love to do this again. Oh, good question. Does New Jersey accept POAs from other states? Oh, and I'm already getting the hook. Okay. So we have to look at your POA. The power of attorney has to have the language for New Jersey in it, and it needs to be at least notarized. So you would want to at least have a lawyer look it over for you. All right. So with that, I'm going to stop the recording.